So welcome everybody. My name is Jordy Ayton. I'm pleased to introduce Ian Hull to our panel today on testamentary capacity issues. And Ian is no stranger probably to anyone here, probably the foremost authority on will issues, an author of many texts, a good friend of mine, my colleague at Hull and Hull, and co-creator of eState Planner, our software. So welcome to eState Academy, and today's session is on testamentary capacity issues, and this is part one of our series on this very issue. So I'm going to turn it over to Ian, and I'll run the slide deck for you.
Thanks, Jordy. Well, thanks very much for having me, and I'm glad to be here and glad to talk about a topic that's near and dear to my heart, testamentary capacity. I just want to start with basic principles that I like to go through in my mind. There are two aspects of it. One is the practical aspect of testamentary capacity, and that is this. We as lawyers or advisors are obligated and charged with the responsibility of determining this question. None of us are, most of us anyway, there's the odd, I remember a former Minister of Cabinet, Bill Davis's cabinet was a lawyer and a doctor, Dr. LG, I remember that, but most of us aren't medical practitioners as well. And so, yeah, this is a medical practitioner type determination. So, but we're judged. At the end of the day, we're the ones who are judged. So I look at this question of mental capacity as not as much about what the answer is, as much as it is about what is the process and what process am I going to undertake, because I'm going to be judged either by the beneficiaries and maybe it gets escalated to the courts. And what have I done to test the mental capacity question and test testamentary capacity? So I start with that knowledge, and I do this because I want to provide good service to my clients, and I also want to be able to have a defendable position, which requires me to understand two parts of this. One is, of course, the test itself, and number two is, what did I do to come to my conclusion of a finding of capacity or not? And so let me start it just at a high level. And this first screen is really the one that I'm a big visual learner, and these three elements of testing capacity are foremost in my mind at all times when I deal with this question. Mental capacity, or testamentary capacity in our case, is specifically a three-part process. One is it's situation specific. So we need to know what are the circumstances. How and what did you determine to be the situation? i.e., and this is, we're going to go through some of the questions that we want to look at, but are there a history of mental frailty, or do we have some red flags that have come off the page, such as situations where someone might be critical of an influencer or something like that? So you want to look at your situation and make sure you've documented that search of how did you come to this conclusion of what the situation was. The next is time specific, and that's a very narrow legal point in the sense that testamentary capacity is as at the time of the will, except there is some case law that says that you can have capacity when you get instructions, but you can ultimately sign later if you've lost your instructions. And that's a bit of a rabbit hole we don't need to worry so much about because it rarely happens. The key is time specific. It is of the moment. And the lawyer or the advisor is the one who is going to be questioned because you're the one who is there at the moment. So it's time specific. The last is, of course, task specific. And what is the task that you're being asked to undertake? If it's just changing the executors, the threshold of one's ability to have cognitive strength is much lower. That's just the reality. If it's a complex situation, coming back to my situation specific, like i.e. writing a kid out of your will, then the task is a higher level of cognition that's required. And this has been shown time and time again by the medical literature. So I like to just be able to make sure I've identified these three aspects of the capacity. Number two, not being as crucial because you're going to be directly involved with it. But the first one is, what is the situation? And The third one is, what is the task? Then the last part of this that I hover around in my small brain is I say, the test for testamentary capacity is really no more complicated than to know and understand the nature and effect of your dispositions and those who would typically be subject to your bounty. And so, you know, the Banks Goodfellow was the test, and the testamentary capacity itself. We've all learned it or seen it enough in the wills world, and we set out in the slide it more particularized. But know and understand the nature and extent of your assets and those who would enjoy your bounty. If I can come out of my testing with the client with those components satisfied and documented, I'm typically going to find a finding in my own mind of testamentary capacity. So Jordy, let's talk a little bit about the situation specific part, because it will feed the task specific. You will ultimately, as you take your instructions, get an idea of what the task is. Sometimes you may not even know before you've met with the client. The situation specific aspect of it is the crucial point. And that is, quite frankly, the point where we need to protect ourselves as professionals as well. So what is it we need to do to determine the situation specific? And maybe, Jordy, you've started with the family tree, and purposely estate planner has the family tree at the start, because I can't tell you in my experience how many cases I've done where that fundamental element wasn't inquired into and therefore brought about, it discredited all of the underlying situation specific evidence that you pulled together, because you missed someone major. You missed someone who was clearly going to be an undue influence, or you missed a niece that should have been taking in a legacy. So I take the time to insist on the situation specific. I take the time to insist on the family tree. And that's why we've tried to work so hard at making this family tree easy to input, both from the client stage and at the stage of review. So Jordy, do you want to make some comment?
Yeah, just on the whole concept of situation specific. So when we talk about that, and Dr. Ken Schulman, who's a world-renowned expert in testamentary capacity, talks about the level of cognition needed to make a certain decision is based around what are the elements or what are the factors that might influence that decision. So for example, an elderly person who has 2 kids, a GIC, and everybody gets along, the cognition necessary to have testamentary capacity to make a will that divides everything equally is lower, in a sense, than a complicated set of assets, a family dynamic with estrangement, those kinds of issues that will make it, in essence, make the test harder to meet. The level of cognition necessary to have capacity with respect to that situation is higher than in the simpler situation. And I think that's how the 2 key elements, right, Ian, if we were to break down what makes up a situation, I always think of the 2 key elements, which is the relationships and the assets. Is that fair to say?
Absolutely, because it takes you to the task, and we have clearly been criticized as lawyers when we don't have those elements under full control in terms of our information flow, and then that of course feeds the task. Because then we can come back too. Once we found out the nature of the situation specific questions, then you feed the task. And as you say, how much maybe we have to go back and get more situation specific facts if the task is of a higher complexity. So Jordy, you're now identifying a great point, and that is, what are these special circumstances?
Right. So what are these are all elements, I think, Ian, that you'd say these key into the situation. These are the situational issues. Maybe you can just address them basically when you're gathering this data about the family and the situation. These are the ones that we use to to sort of flesh out the situation. So maybe you want to address the issue of estrangement, for example.
Yeah, and what we purposely do is actually put these keywords out because they will help trigger. It's not always evident when you're taking your instructions as to what the situation is. Clients are resistant to give asset information, and they're certainly resistant to give, at some level, they're resistant to give what's going on internally with the family and the family shtick, so to speak. So if you can get to it, and it comes back to documenting it. If you can get to these questions with a direct question, specific, not too open-ended in respect of the topic, and then you can check that box and say, the question was asked. It's a huge documenting tool. So estrangement's an obvious easy one. You got 3 kids and you say, boy, what ages are they? And oh, they're at school or whatever. And then all of a sudden you can hear that one of the kids you haven't heard anything about. Well, just in my view is ask about if there's any estrangement. And then I've got right in the program, we just there and we will make a note either way. We've documented it. It's helping the client because the estrangement will affect our planning for sure. But it's helping you because you've documented it.
So when I'm confronted with an estrangement, a person in the family, as you say, a person who's expected to receive the bounty of this person's assets on death. I mean, the first question I ask is, when did it start? That's to me really important. Obviously, there's lots of follow-up questions. I'll say why I focus on that. Often they will say to me, well, it's been, I haven't spoken to them in 10 years. And you look and one of the questions is, let me see your prior will. And sure enough, 2 years ago, they were still in the will. And so that would prompt, think about on an examination for discovery and what you'd go to town on me. And I'd say, well, they were estranged. And you'd say, well, they were estranged for 10 years. What's the difference between year 8 and year 10? So the idea that, okay, you've been estranged and that has continued for X period of time, and you're doing something different now is really crucial, because you can see how if the estrangement was since the last will, that makes some sense, right? And if it's farther back, it's.
No, that's such a good point, because it's sort of like doctor's notes, one-liners, and they say they have testamentary capacity. Well, that's not of any use in most litigation scenarios. Well, just saying estranged, just because you asked without probing, if you've got an answer that there is estrangement, it's crucial to set the stage to find out why, because it's going to be the obvious question. I always think of this. Number one, the way you've described it is, what are the questions going to be asked of me? And number two is, at the end of the day, I'm here to try to achieve a result for my client. And to do that, and I'll say this flat out, I'll say, I know this is a personal question, and maybe you don't want to talk about it, but if you want me to achieve the results you want me to achieve, and that is create a valid and subsisting will, then I have to ask these questions. And I've never had a client turn to me and say, oh, I'm still not going to answer it. Right? Once they understand why you're probing into what might seem to be personal affairs, they get it. In most cases.
And I think, so that's the estrangement, and that's going to be the most important one, right? I mean, that's the one that's likely going to affect the disposition by the client. And so I know that often you'll hear, especially from an elderly person, why are you estranged from your daughter-in-law or your son, or while they're stealing from me, right? That classic, they're stealing from me. I've heard doctors say that if a client presents with that explanation, prima facie, they have dementia. And if they show up and they say, oh, you know what, my memory's going, I can't remember anything, prima facie, they have depression. But that is a warning signal, right, on capacity. If they start alleging things like someone stealing from me, right, Ian, like how would you deal with that kind of fact scenario or those
Well,
kinds of descriptions?
it's a great question because I've got one. I litigated about 5 years ago, and this was a person. He was a sophisticated business person, and he kept saying that it's estranged from his one of his daughters because she stole a mortgage. And this is a guy that was in the real estate business, and he thought that he came to his office and took papers and stole a mortgage. Well, of course, you can't by way of paper steal a mortgage. And as soon as the explanation was given to me, in cross examination, I just went to town on it because I'm like, this guy's been in the business. He knows that in a strong cognitive situation, he would have known you can't steal a mortgage per se, and you made no further inquiries. No, I accepted on the face of it. Well, that was a real downfall because what it does is it has the tumble effect. And that is, of course, that you're going to look like your next answer is not very satisfactory because you've already and we put estrangement at the top because it is really the one thing that if there is evidence of estrangement, it needs to be carefully canvassed just from a validity standpoint. Otherwise, you start undermining all of your evidence.
And these all go to, just to tie it into the capacity issue, right? These kinds of factors, estrangement being the big one, makes the situation more complex, requiring a higher level of cognition to be able to balance those and make judgments about them, right? Can we skip down to relationship difficulties, and what do you see that, and how is that, the idea that this beneficiary, Robert Grant, has relationship difficulties with his sister, for example? Are you going to go that far in assessing the family and the situation?
So I think, again, we have to consider that we're in a situation where we are starting to identify some red flags, and we want to make further inquiries beyond the normal inquiries that we would make, and that we've already started to sense something. So relationship difficulties is very different than estrangement per se. And I personally don't go as deep on the relationship difficulties if I'm getting satisfactory and sensible logical answers. And the classic answer is typically, well, the kids get along, but they fight from time to time. And then I'll start to say, okay, well, then so you don't see any difficulty because, of course, they're going to have to get along with a lot of cooperation for the administration part and so on and so forth. And I start to probe the kind of level of cooperation they're going to need to be involved with. But if I get a pretty straight answer out of that, I find it difficult. I don't know about you, Jordy, but I do find it difficult to get into too much of the granular. Life is busy, and you tend to not want to dwell on parts of the intake that aren't going to be relevant. And secondly, that starts to get gossipy, and it's not unless it's being volunteered. It is more difficult and time consuming. And the truth is, siblings always fight, and there's always shtick within the family. I just need to know if it's at the threshold of it's going to impact the administration or impact the instructions.
The reason that I would look a little bit deeper in this, I'm talking, and right now we're talking about, this is not your couple who's 50 years old and have young kids. I'm talking about, an elderly person. The reason I think this is important, and it goes to the situational complexity. If you've got two kids who don't get along, the dynamic typically is that each is vying for the parent's favor, as it were. And one is bad mouthing the other to the parent. It's very common that you see that. And what that does is it puts the parent, obviously, who loves both kids, in a terrible situation. They don't want to hurt one. They want to validate the other. And all that does really is make it a more difficult situation for the client. And that's why I think it ties in with the capacity that if you've got people warring, especially close family members, that can raise the level of difficulty in the situation that may require a tougher level of cognition.
Absolutely. And that fact, I'm just saying most of the time you get a pretty vague answer on that. If your inquiry starts to tease out anything that starts to show an honest answer of serious discord, I agree with Jordy 100%. You know, it's just my personal experience is it's just hard to get that because people not only do they love me equally, they have rose-colored glasses and they all think, oh, they get along fine.
Yes. When I asked you, kids get along, they always say, oh, yes, yes. And then there's often a pause. I don't respond yet. And there's often a pause. And oh, when was the last time they, got together? Oh, well, they don't really speak, and sure enough, by the time you end, they can't stand each other. But it's often some diving down. So these kinds of situational questions that we're going to ask go to capacity. And often they're not the classic issue on capacity, right, is the client's sort of mentals, which we'll talk about in a moment. But the situation, this is what sort of sets out the situation that can affect the level of capacity and the inquiries that we need to make and document, right?
Absolutely.
The other component, what do you say, Ian, about gathering asset information? How does that tie in with the capacity issues, and specifically the situational specific aspects of testamentary capacity?
Well, as you say, I mean, more complex the assets, at some level, you want to you may you, the your client may have to have a higher level of cognition. Now, I say that balancing the case law, which has universally said almost that very rich people don't really need to know what their assets are. They just need to know they're very rich. But the real world, most of us, the understanding the nature and extent of their assets is obviously part of the criteria, but it feeds good planning and it feeds the capacity question just so profoundly. And whether or not they know exactly what their RSP is at isn't really the question I get fussed about. I want to know general information if I can, and then I can always ask for more if I need it later, or I can ask them to send it in. But if they have completely, and they're not in the world of the very rich who maybe only understand the basic parameters of their wealth, you need to, I need to anyway, feel comfortable is to get as much of information as I can on the nature and extent of their assets. Again, it's an easy, in the litigation world, it's an easy hit, right? If a lawyer has not taken really made any effort to determine the nature and extent of the testator's assets, then, you're just opening yourself up. It's not fatal. And that's what the cases have identified from time to time, but it is a real Achilles heel to the extent of the worth of your evidence.
And how do you see that, like on the task specific? I think the task specific capacity point also ties in with the investigation of assets. So, for example, appointing an executor, if you're doing a codicil to appoint an executor, then the extent of your assets are less important. And then the cognition about understanding the extent of your assets might be completely irrelevant even. What do you see as some of the tasks that make the asset component of a client's information more important in the issue of capacity?
Well, I think the nature of the assets drives the task of the planning and what planning you're going to be undertaking. And so, if someone has a complex portfolio with assets all across the world, including tax-driven holdings and the good old days, limited partnerships and so on and so forth. That's going to affect your planning considerations, and it's also going to affect your ability to explain to the deceased what they're doing in their will. And so the level of cognition expected there can be affected for sure. But again, I think the key is, if we're going to do a good job, getting the assets under control drives the planning, which drives the testing of capacity. But there's a balancing act. We can't get to the point where we're letting it's sort of like the example I always use is, if you don't know the exact level of your RSP or something like that, I don't want to stop the planning process. It would be nice to know, and I'm happy to get it, but let's get some general ideas here. And I see, the way you do it is the way I do it. I typically take some round numbers. And then later, if I find out that the round numbers are completely off, or someone that says, look, my cottage is worth $10 million, and I ask 2 or 3 questions, and I say, you know what, a small bungalow on a no boat lake in the middle of Algonquin Park may not be worth $10 million. I start to get a red flag as a consequence of that inquiry.
And the other thing that I think that ties into the concept of task specific, the idea of dividing everything I own, so the balance of the estate, the residue of the estate, in a sense, at that point, the importance of the asset, of a particular asset, is lower than if the task that the person is coming up with is how to give away specific assets or specific amounts. Because at that point, then you're into a situation where relevance of an asset to the total is part of the judgment and decision making. If everything's just going to be lumped in, then it doesn't matter if you own it as a house or a bank account. But as soon as you're starting to give away, the home to Franklin and the cottage to Tracy, then that task of making that decision is much more complicated and does require that. And again, then it feeds into the issue of capacity, because capacity is task specific. And so where the person might have been able to say, divide everything 50-50, they may not necessarily, without the higher level of cognition, understand giving one asset to one person, a specific amount to this person, the tax implications of those things. So that's how I think task specific issues are relevant with assets and how assets feed into the task specific as well as the situation specific. So what I thought we'd do is that's if we're going to likely end our first part on that, setting up the 3 components of testamentary capacity. And then what I thought we'd do in the next one, Ian, if you don't mind coming back, is talk about, okay, from a practical point of view, how do we protect ourselves through, what should the file look like? What do we do when we see a red flag? What kind of probing questions we have, and what does our file consist of at the end of the day? And if you don't mind, that would be great. So before and we'll take a few questions if that's okay. Let's maybe ask, if I can just address a couple of questions to you. What do you do about gathering information from advisors, from a third party? Do you think for capacity purposes to test, tell me what's in your bank account, tell me what's, what assets you have? How would you deal with that?
Well, again, it's so fact specific, right? If we're dealing with a situation where I've got concerns about testamentary capacity, I will often press and try to get more information from third parties to help verify that I'm on the right track, and that when someone describes their portfolio of having $300,000 and it turns out to be $30, that's a big difference and a big swing that would be identifying understanding the nature and extent of your assets. So I don't always do it, but I will use that as a tool, as a further drill down step. And then again, I'd like to say, look, at the end of the day, we want to be able to be in a position where we can assist at the administration level if we need to. And so the more accurate we know now, the better. And secondly, more importantly, is I want to do a good job for you. And part of doing a good job is to get that information. But getting it from third parties can be a bit of a headache. And sometimes I have my clerk chasing that down for the client, because it's just something that isn't going to get done unless you get someone else on it.
So we have one other question, and we have a bunch, but some of them are going to tie better into the next session where we talk about sort of what do you, how do you document these things? But what about a situation where somebody has the capacity to simply split the residue, so a simple level of capacity, but they might not have the capacity to deal with a more complicated thing, disposition. Is there, and maybe we can defer this to next week, but is there something that you can do about that? Especially if the instructions are, I want to give the house to one person and the cottage to the other. Is there anything that jumps to mind on the mental capacity spectrum that you can do about that?
Well, I think one of the things I really worry about when I get into unequal distributions within a family is that's why testamentary capacity is so vital of a determination. And I don't want to be cavalier about it. And so I will certainly make it clear that it's unequal, and using the visual descriptions is just a huge tool to help people go, oh my gosh, I see what you mean. Now that's why it would happen. But secondly, and we can talk about this more too as well, is what do we do about that? Often I will insist on a capacity assessment, and I can go through next week some of the steps I take in that regard. I will proudly push that forward, because as soon as you get a clear unequal distribution, you're creating your own red flag by not following it up.
Great. So I want to we like to keep it to a half an hour. So it's easily digestible. And so we hope that you'll join us again at East State Academy for our next session on testamentary capacity, more from a practical point of view, practice and malpractice point of view, to help protect us. And so we welcome, and if you want to send us some questions in advance, we can do it that way as well. We hope to cover a bunch of the topics, but this is such an important topic that we need to, and quite frankly, the whole thinking is emerging. I mean, we never thought of testamentary capacity situation specific, time specific, task specific. It was either on off, and so it's evolving, and the literature is evolving, and the case law is evolving. And so I thank you, Ian, so much for joining us, and thank you all as well. And we'll hopefully see you again next week. Take good care, everyone.